We will go back on the record in the matter of State versus Zelenski. The appearances are, as previously noted, we are outside the presence of the jury. I did forward to counsel via email yesterday afternoon the proposed jury instructions. I understand you would have an alternative instruction as it relates to 1014, Ms. Isherwood. Is that correct?
Yes, Your Honor. In the proposed 1014, when you get to the elements of the crime, there is nothing about provocation in it. And while we're giving them a provocation instruction, nowhere in the instruction does it tell them what to do with that. What I proposed has, and this is from a trial that actually went in Ashland County, and they have as the element, which I believe is appropriate, and I'm just looking for it, they have the provocation language in the element. He either was not allowed to use or threaten force in self-defense due to provocation, or did not actually believe that the force used was necessary. And I think that's very important. As they get down to the final question, they're going to be applying the elements, and if provocation isn't in the elements, I think it would cause undue confusion. They're going to have that instruction on provocation and what they are to consider, but they aren't going to be told what they're allowed to do with it, because it does affect their final verdict, or it could.
Mr. Hogan?
Your Honor, I think the way that the court provided the instructions is appropriate, because the provocation in, I think that would have been 810 or 815, doesn't really indicate how to include it within the elements. It just indicates also read this if provocation is an issue. So my concern is that in the jury instructions as listed, it does not, the standard instruction doesn't indicate that you should include the provocation language in the elements. So I think that the way that the court has it listed and noted is appropriate.
Well, you will note that the provocation language is incorporated in the privileged self-defense instruction immediately after retreat. And the way I have prepared the instructions, quite frankly, I think that the language you are proposing, Ms. Ishwood, may further confuse a jury. All of a sudden, within your proposed instruction, it's talking about a completely different criminal offense, disorderly conduct, which the jury hasn't heard a word about.
No, Your Honor, I just gave you the Ashland County instruction. I did not draft it for this case. I just did a statewide inquiry last night, and Ashland County sent me this instruction. I'm just looking at the elements of intentional homicide within this instruction. It talks about a different defendant and a different victim in this case. I sent it as is, frankly, because of lack of time. I mean, I could take this instruction and draft it. What I'm concerned about is the elements of the crime. The elements of first-degree intentional homicide that caused the death of Ryelee Manente Powell. Cause means the defendant's act was a substantial factor in producing the death. The defendant acted with intent to kill Ryelee Manente Powell. and the defendant either was not allowed to use or threaten force in self-defense due to provocation, or did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself. That's the line I'm concerned about, the element. And in the element that we got in the proposed jury instruction, it just says the defendant did not actually believe that the force used was necessary. That completely leaves out all provocation language for the jury to consider when they're actually looking at the elements of the crime and coming to a decision.
Except within the provocation portion that the court submitted, it says you should also consider whether the defendant provoked the attack. A person who engages in unlawful conduct of a type likely to provoke others to attack and who does provoke an attack is not allowed to use or threaten force in self-defense against the attack. I think that's an accurate statement of the provocation law. And so I'll note your objection, but as it relates to the 1014 and call it 805, 810, 815 instructions, I'm going to give them as prepared. Any other objections from the state?
Well, Your Honor, then I just want to note, then you're saying that that's the law, then I can tell them if they find it was provoked and the defendant did not do that, that they should find him not, or they should find him guilty.
You can make your argument consistent with the law, always.
Right. But because it's not listed as an element, I just foresee confusion, and the state's entitled to a fair trial as well here.
Absolutely. You can certainly discuss the provocation and whether that eliminates the possibility of self-defense. But also, as I think everyone's aware, that even if there is the provocation, that does not eliminate the self-defense depending upon recovery of that right. So
but that's not in the substantive instruction.
that's not in the substantive, but it's implicit in the 805, 810, and 815 instruction. So other than that, any objections from the state?
No, Your Honor.
Ms. Hogan, any objection from the defense?
Just one with respect to 482 and the verdicts. As was addressed in a previous motion in limine, we'd be asking that the reading start off the first reading of we the jury find the defendant William C. Zelenski not guilty, and that the not guilty verdict be the first verdict submitted because he's presumed to be not guilty. That was a previous motion in limine that we addressed that the court had granted.
And I think at that time we were anticipating a simple guilty, not guilty verdict on a sole count of first degree intentional homicide. That would not be applicable in this case because the self-defense and the issue of possible second degree homicide requires an evaluation of the first guilty or not guilty, well, guilty, excuse me, on first degree intentional homicide. Then if that's not found, then they review the second degree. And then if that's not found, that's where we reach not guilty, I believe. So I'm going to give 482 as printed. Any other objections from anyone?
No.
No, Your Honor.
And will counsel be ready to go straight to closing after I stop the instruction, or do you need some time to set up exhibits? Or
I've already set mine up.
I should be ready to go after the state.
okay,
So I just asked the bailiff to, well, I can move the easel now. I don't want the jurors not to be able to see you.
I think they can, and it's just as well if they don't.
Oh, no, it's not getting off that easy. Is this okay for security?
think we said we'd start at 10, so I think we just need to wait a few minutes. Did I say 9? I meant 10. I meant to say 9.
But we all heard what you meant.
Thank you.
It is about 10 minutes, so that's where you're.
Yeah, I was thinking it's 10 minutes.
The court is also going to read 460, right, the closing instruction. Yes. I didn't see it in the packet.
No, just better. We'll go back in the record. We are outside the presence of the jury. Ms. Ishwood?
I was just gonna ask if in the provocation instruction, you can make it for this case. It says he or she in it, and,
Obviously, it should be he if we missed that one.
Right, and, you should also consider whether, William Zelenski provoked the attack. That would be my proposed change. And then in the second paragraph, if the attack which follows caused William Zelenski to reasonably believe he. The other ones were made to fit the case, so I think that would be appropriate.
First, let's talk about the he and she. I don't see any, oh, in the provocation second paragraph. All right. I will read it as he. I will just read it as he's. All right, and then you want well, I think everyone knows who the defendant is. If you wanted to see, while we were off the record, counsel pointed out that I missed including 460. Here's the 460 for your packets. But I will read the provocation as he. I'm not going to modify the ones that are printed. The jury can figure out we're talking about he. He's the only one who's claiming self-defense, and the only one that would be relevant to. And so you're asking that rather than referencing him as the defendant, that I put his name in?
I was, just because I plan on displaying it, and I want it to be exactly as you're reading it.
And have you prepared an exhibit that shows his name rather than defendant?
Well, we haven't printed it yet.
Then I'm just going to, rather, now we're past 9, I want to get the jury in, so I'm going to read it as printed. They know who the defendant is here. Okay, and so in your packets, I'm inserting 460, obviously before 482 and immediately after closing arguments of counsel. That's when I'll be taking a break to allow you to make your closing arguments. Anything else we need to talk about before we bring the jury in?
No.
Well, ladies and gentlemen of the jury, I want to truly thank you for your attention and your promptness and your dedication to your service as jurors. I indicated at the start of the trial, I know it's an inconvenience and a burden on you. So I truly appreciate the time you've taken in this last week to commit yourselves to your service as great citizens to make ours the best judicial system in the world. We now are at the time of the trial where I will instruct you on the principles of law. The attorneys will have an opportunity to make the closing statements, and the case will be then turned over to you. But I wanted to be sure to take this opportunity to truly thank you in case in the heat of the moment I forget to. Your work is truly appreciated. Thank you. I will now instruct you on the principles of the law, which you are to follow in considering the evidence and in reaching your verdict. It is your duty to follow all of these instructions, regardless of any opinion you may have about what the law is or ought to be. You must base your verdict on the law I give you in these instructions. Apply that law to the facts in the case which have been properly proven by the evidence. Consider only the evidence received during the trial and the law as given to you by these instructions, and from these alone, guided by your soundest reason and best judgment, reach your verdict. If any member of the jury has an impression of my opinion as to whether the defendant is guilty or not guilty, disregard that impression entirely and decide the issues of fact solely as you view the evidence. You, the jury, are the sole judges of the facts, and the court is the judge of the law only. Self-defense is an issue in this case. The law of self-defense allows the defendant to threaten or intentionally use force against another only if the defendant believed that there was an actual or imminent unlawful interference with the defendant's person, and the defendant believed the amount of force the defendant used or threatened to use was necessary to terminate the interference, and the defendant's beliefs were reasonable. The defendant may intentionally use force which is intended or likely to cause death or great bodily harm only if the defendant reasonably believes that the force used was necessary to prevent imminent death or great bodily harm to himself. A belief may be reasonable even though mistaken. In determining whether the defendant's beliefs were reasonable, the standard is what a person of ordinary intelligence and prudence would have believed in the defendant's position under the circumstances that existed at the time of the alleged offense. The reasonableness of the defendant's beliefs must be determined from the standpoint of the defendant at the time of the defendant's acts and not from the viewpoint of the jury now. There is no duty to retreat. However, in determining whether the defendants reasonably believed the amount of force used was necessary to prevent or terminate the interference, you may consider whether the defendant had an opportunity to retreat with safety, whether such retreat was feasible, and whether the defendant knew of the opportunity to retreat. You should also consider whether the defendant provoked the attack. The person who engages in unlawful conduct of a type likely to provoke others to attack, and who does provoke an attack, is not allowed to use or threaten force in self-defense against that attack. However, if the attack which follows causes the person reasonably to believe that he or she is in imminent danger or death or great bodily harm, he or she may lawfully act in self-defense. But the person may not use or threaten force intended or likely to cause death unless he or she reasonably believes he or she has exhausted every other reasonable means to escape from or otherwise avoid death or great bodily harm. The defendant in this case is charged with first-degree intentional homicide, and you must consider whether the defendant is guilty of that offense. If you are not satisfied the defendant is guilty of first-degree intentional homicide, you must consider whether or not the defendant is guilty of second-degree intentional homicide, which is a less serious degree of criminal homicide. The crimes referred to as first and second-degree intentional homicide are different degrees of homicide. Homicide is the taking of the life of another human being. The degree of homicide defined by the law depends upon the facts and circumstances of each particular case. While the law separates intentional homicides into 2 degrees, there are certain elements which are common to each crime. Both first and second degree intentional homicide require that the defendant cause the death of the victim with intent to kill. It will also be important for you to consider the privilege of self-defense in deciding which crime, if any, the defendant has committed. The Criminal Code of Wisconsin provides that a person is privileged to intentionally use force against another for the purpose of preventing or terminating what he reasonably believes to be an unlawful interference with his person by the other person. However, he may intentionally use only such force as he reasonably believes is necessary to prevent or terminate the interference. He may not intentionally use force which is intended or likely to cause death unless he reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself. As applied in this case, the effect of the law of self-defense is the defendant is not guilty of either first or second degree intentional homicide if the defendant believed that he was preventing or terminating an unlawful interference with his person and reasonably believed the force used was necessary to prevent imminent death or great bodily harm to himself. The defendant is guilty of second degree intentional homicide if the defendant caused the death of Ryelee Manente Powell with the intent to kill and actually believed the force used was necessary to prevent imminent death or great bodily harm to himself, but the belief or the amount of force used was unreasonable. The defendant is guilty of first degree intentional homicide if the defendant caused the death of Ryelee Manente Powell with the intent to kill and did not actually believe the force used was necessary to prevent imminent death or great bodily harm to himself. Because the law provides that it is the state's burden to prove all the facts necessary to constitute a crime beyond a reasonable doubt, you will not be asked to make a separate finding on whether the defendant acted in self-defense. Instead, you will be asked to determine whether the state has established the necessary facts to justify a finding of guilt for first or second degree intentional homicide. If the state does not satisfy you that those facts are established by the evidence, you will be instructed to find the defendant not guilty. The elements of each crime will now be defined to you in greater detail. First degree intentional homicide, as defined in section 940.01 of the Criminal Code of Wisconsin, is committed by one who causes the death of another human being with the intent to kill that person or another. In this case, first degree intentional homicide also requires the defendant did not actually believe the force used was necessary to prevent imminent death or great bodily harm to himself. Before you may find the defendant guilty of first degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. First, that the defendant caused the death of Ryelee Manente Powell. Cause means that the defendant's acts was a substantial factor in producing the death. Second, the defendant acted with intent to kill Ryelee Manente Powell. And third, the defendant did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself. Intent to kill means the defendant had the mental purpose to take the life of another human being or was aware that his conduct was practically certain to cause the death of another human being. While the law requires the defendant acted with intent to kill, it does not require that the intent exists for any particular length of time before the act is committed. That need not be brooded over, considered, or reflected on for a week, a day, an hour, or even for a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. The defendant contends that he did not act with intent, but rather that what happened was an accident. If the defendant did not act with intent required for a crime, the defendant is not guilty of the crime. Before you may find the defendant guilty of intent, the state must prove by evidence that satisfies you beyond reasonable doubt that the defendant had the intent. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances, in this case bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to the person's reasoning or reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of the defendant, the state is not required to prove motive on the part of the defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all these circumstances. The third element of first-degree intentional homicide excuse me. The third element of first-degree intentional homicide requires that the defendant did not actually believe the force used was necessary to prevent imminent death or great bodily harm to himself. This requires the state to prove either that the defendant did not actually believe he was in imminent danger of death or great bodily harm, or that the defendant did not actually believe the force used was necessary to prevent imminent danger or death or great bodily harm to himself. When first-degree intentional homicide is considered, the reasonableness of the defendant's belief is not an issue. You are to be concerned only with what the defendant actually believed. Whether these beliefs are reasonable is important only if you later consider whether the defendant is guilty of second-degree intentional homicide. If you are satisfied beyond a reasonable doubt that the defendant caused the death of Ryelee Manente Powell with intent to kill, and that the defendant did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself, you should find the defendant guilty of first-degree intentional homicide. If you are not so satisfied, you must find the defendant. If you are not so satisfied, you must not find the defendant guilty of first-degree intentional homicide, and you must consider whether the defendant is guilty of second-degree intentional homicide, as defined in Section 940.05 of the Criminal Code of Wisconsin, which is a lesser included offense of first-degree intentional homicide. You should make every reasonable effort to agree unanimously on the charge of first-degree intentional homicide before considering the offense of second-degree intentional homicide. However, if after full and complete consideration of the evidence, you conclude that further deliberation would not result in a unanimous verdict on the charge of first-degree intentional homicide, you should consider whether the defendant is guilty of second-degree intentional homicide. Before you may find the defendant guilty of second-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. First, the defendant caused the death of Ryelee Manente Powell. Second, the defendant acted with intent to kill Ryelee Manente Powell. And third, the defendant did not reasonably believe that he was preventing or terminating an unlawful interference with his person, or did not reasonably believe the force used was necessary to prevent imminent death or great bodily harm to himself. You have already been instructed on the definitions of causing death and with intent to kill. The same definitions apply to your consideration of second-degree intentional homicide. The third element of second-degree intentional homicide requires the defendant did not reasonably believe that he was preventing or terminating an unlawful interference with his person, or did not reasonably believe the force used was necessary to prevent imminent death or great bodily harm to himself. This requires that the state prove any of the following: that a reasonable person in the circumstances of the defendant would not have believed that he was preventing or terminating an unlawful interference with his person, or that a reasonable person in the circumstances of the defendant would not have believed he was in danger of imminent death or great bodily harm, or that a reasonable person in the circumstances of the defendant would not have believed the amount of force used was necessary to prevent imminent death or great bodily harm to himself. A belief may be reasonable even though mistaken. In determining whether the defendant's beliefs were reasonable, the standard is what a person of ordinary intelligence and prudence would have believed in the defendant's position under the circumstances that existed at the time of the alleged offense. The reasonableness of a defendant's beliefs must be determined from the standpoint of the defendant at the time of the defendant's acts, and not from the viewpoint of the jury now. If you are satisfied beyond a reasonable doubt that the defendant caused the death of Ryelee Manente Powell with intent to kill, and did not reasonably believe that he was preventing or terminating an unlawful interference with his person, or did not reasonably believe the force used was necessary to prevent imminent death or great bodily harm to himself, you should find the defendant guilty of second-degree intentional homicide. If you are not satisfied beyond a reasonable doubt the defendant is guilty of second-degree intentional homicide, you must find the defendant not guilty. You are not in any event to find the defendant guilty of more than one of the foregoing offenses. In reaching your verdict, examine the evidence with care and caution. Act with judgment, reason, and prudence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty unless in your deliberations you find it is overcome by evidence which satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you can return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the defendant's innocence, you should do so and return a verdict of not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt about such as may be used to escape the responsibility of a decision. While it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt, you are to search for the truth. And information is nothing more than a written formal accusation against the defendant charging the commission of one or more criminal acts. You are not to consider it as evidence against the defendant in any way. It does not raise any inferences of guilt. Evidence is first the sworn testimony of the witnesses, both on direct and cross-examination, regardless of who called the witness. Second, the exhibits the court has received, whether or not an exhibit goes into the jury room. Third, any facts to which the lawyers have agreed or stipulated, or which I have directed you to find. Anything you may have seen or heard outside the courtroom is not evidence. You are to decide the case solely on the evidence offered and received at trial. It is not necessary that every fact be proved directly by a witness or an exhibit. A fact may be proved indirectly by circumstantial evidence. Circumstantial evidence is evidence from which a jury may logically find other facts according to common knowledge and experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. Whether evidence is direct or circumstantial, it must satisfy you beyond a reasonable doubt that the defendant committed the offense before you may find the defendant guilty. Remarks of the attorneys are not evidence. If the remarks suggest certain facts not in evidence, disregard the suggestion. An exhibit becomes evidence only when it's received by the court. An exhibit marked for identification and not received is not evidence. An exhibit received is evidence whether or not it goes to the jury room. Attorneys for each side have the right and duty to object to what they consider are improper questions asked of witnesses and to the admission of other evidence which they believe is not properly admissible. You should not draw any conclusion from the fact an objection was made. By allowing testimony or other evidence to be received over the objection of counsel, the court is not indicating any opinion about the evidence. You jurors are the judges of the credibility of the witnesses and the weight of the evidence. Disregard entirely any question that the court did not allow to be answered. Do not guess at what the witness's answer might have been. If the question itself suggested that certain information might be true, ignore the question and do not consider it as evidence. During the trial, the court has ordered certain testimony to be stricken. Disregard all stricken testimony. The weight of the evidence does not depend on the number of witnesses on each side. You may find the testimony of one witness is entitled to greater weight than that of another witness, or even of several other witnesses. In weighing the evidence, you may take into account matters of your common knowledge and your observations and experience in the affairs of life. It is the duty of the jury to scrutinize and to weigh the testimony of witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses and the weight to be given to their testimony. In your determination of credibility, you must avoid bias, conscious or unconscious, based on the witness's race, national origin, religion, age, ability, gender identity, sexual orientation, education, income level, or any other personal characteristic. In determining the credibility of each witness and the weight you give the testimony of each witness, consider these factors. Whether the witness has an interest or a lack of interest in the results of the trial. The witness's conduct, appearance, and demeanor on the witness stand. The clearness or lack of clearness of the witness's recollections. The opportunity the witness had for observing and for knowing the matters the witness testified about. The reasonableness of the witness's testimony. The apparent intelligence of the witness. Bias or prejudice, if any, has been shown. Possible motives for falsifying testimony. And all other facts and circumstances during the trial which tend either to support or discredit the testimony. Then give to the testimony of each witness the weight you believe it should receive. The defendant has testified in this case, and you should not discredit the testimony just because the defendant is charged with a crime. Use the same factors to determine the credibility and weight of the defendant's testimony that you use to evaluate the testimony of any other witness. There is no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourselves the reliability of things people say to you. You should do the same thing here. The testimony of a child should be weighed in the same manner as testimony of any other witness. Consideration of age, intelligence, ability to observe and report correctly, ability to understand the questions and to answer them, sense of duty to speak the truth, conduct on the witness stand, interest, appearance, and other matters bearing on credibility apply to child witnesses in common with all witnesses. Ordinarily, a witness may testify only about facts. However, a witness with specialized knowledge in a particular field may give an opinion in that field. In determining the weight to give to the opinion, you should consider the qualifications and credibility of the witness, the facts upon which the opinion is based, and the reasons given for the opinion. Opinion evidence was received to help you reach a conclusion. However, you are not bound by any witness's opinion. During the trial, a witness was told to assume certain facts and then was asked for an opinion based upon that assumption. This is called a hypothetical question. The opinion does not establish the truth of the facts upon which it is based. Consider the opinion only if you believe the assumed facts upon which it is based have been proved. If you find that the facts stated in the hypothetical question have not been proved, then the opinion based on those facts should not be given any weight. Evidence has been received that some of the witnesses in this trial have been convicted of crimes. This evidence was received solely because it bears upon the witness's character for truthfulness. It must not be used for any other purpose. Consider carefully the closing arguments of the attorneys, but their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence, under the instructions given to you by the court. At this time, the attorneys will be making the closing arguments. Ms. Isherwood.
Thank you.
Somebody took the easel I had set up. Oh. Ryelee Manente, Powell. 977 days ago, he lost his life. He lost his life when Bill Zelenski put a shotgun, double-barreled, in his armpit and pulled the trigger. Dr. Kovacs testified that the shotgun blast at that close range caused Ryeelee's death, tore open the bottom of his heart, his aorta. Dr. Kovac opined that he had maybe 10 or 15 seconds of life after that blast. We know Bill Zelenski pulled the trigger and shot Ryelee. He called 911 and he said, Ryelee Manente was walking home. I confronted him. He came at me and I shot him. Throughout the investigation, he claimed it was self-defense. Except that Ryelee Manente Powell did not have a gun. He did not have a knife. He did not have a baseball bat. He had no weapons on him. He was walking home. Bill said he was walking home from the jail where he had been transported because he owed money on a New London fine, municipal court. An intentional homicide requires that the defendant cause the death with the intent to kill. But if you listen to the judge's instructions, it doesn't mean that on the morning of October 19th, Bill intended to kill Ryelee. I don't believe that. I don't think any of you believe that. It doesn't mean that when he drove to Mill Street, or was started to drive to Mill Street, that he thought, I'm going to go to Mill Street and kill Ryelee Manente Powell. Of course not. But as the judge instructed you, that intent to kill can be formed in an instant. And I submit to you that when you pull the trigger of a double-barreled 12-gauge shotgun, which you've already pulled back the hammers, that is intent to kill. It's also in the instructions that intent to kill is the mental purpose to take the life or was aware that his conduct was practically certain to cause the death. Anybody experienced in firearms, you don't have to be experienced in firearms to know that if you put a shotgun against the person and press into them downward and pull the trigger, that it's practically certain they're going to die. Now that's the information we knew back on October 19, 2020, 977 days ago. As of June 19th, 2023, at the beginning of this trial, he wants you to believe that pulling the trigger was an accident. It was Rylee's fault. He didn't tell the dispatcher it was an accident. He didn't tell Tiffany Powell it was an accident, Rylee's own mother. He didn't tell Tara Dalrymple it was an accident when she was at the scene screaming, "Why did you do this?" In fact, he said, "He came at me, I had no choice." Does that sound like an accident? 977 days later, it's an accident. But it wasn't an accident on October 19th, 2020. He didn't tell any of the officers who arrived on scene that it was an accident. He didn't tell Officer Wasrud, Shabilsky, Deputy Thorpe. He told no one until this week. He had 977 days to come up with the accident scenario. That was 977 days that Ryelee didn't have. Now, he testified yesterday on how he was terrified of Ryelee. But he also testified about all of his police training, that once or twice a month he'd come across hostile subjects. He talked about how he was learned to de-escalate situations. He learned how to control a subject, how to place somebody under arrest. So when it's convenient for him, he draws on this police training that at the time he hadn't used in over 15 years when he was separated from the city of Waupaca. But when it's not convenient for him, all thoughts of his police training go out the window. He told you that it was self-defense because he was so terrified of Ryelee. He told you that he turned down Van Street because he had to go tell Tara not to give a ride. All he talked about to everyone was that I need to get the animals back. I need to make sure they're safe. We saw a lot about the timeline that was being prepared here. Please wait. And very familiar with this timeline after this week. But I made an addition to this timeline. Something, can you do it? That's better.
Your Honor, may we approach?
Sure. We are on the record outside the presence of the jury. Mr. Hogan, I take it you're objecting. It says Bill learns location of reptiles.
Specifically, the objection is to the 10:15 and 28 seconds p.m. That was not testified to at all.
Your Honor, that's math. There was testimony at 10:17:45. Bill's call with Danielle ends. We played the call. At the moment that on the call they gave the address of the reptiles, the testimony was there was 2 minutes and 17 seconds left on that phone call. 2 minutes and 17 seconds subtracted from 10:17:45 equals 10:15:28. It's math.
Mr. Hogan.
Your Honor, my recollection of the testimony was when that phone call started and the time in which on the recording there was. I don't recall any testimony of anybody indicating a particular amount of time left in the phone call.
That was the purpose of that testimony, was to identify the exact time that they knew the animal's location. It was the purpose of the phone call that we played. And at the time that Mr. Szilagyi stopped the recording, we put into the record how much time was left. It was for exactly this purpose. I know I didn't do the math, but I don't believe math is a fact that can't be presented. In fact, I have my slip here where I was going.
This is argument. I'm going to allow it, and you're certainly free to argue. That's not what the evidence is. You know, it's an interpretation of evidence, so I'm going to allow it.
Can they fit by there?
Please be seated. You may proceed.
Thank you, Your Honor. So as I was saying, at 10:15 and 28, or 10:15 and 28 seconds is when Bill and Tiffany learned the location of the reptiles. And where does that number come from? We played that call. And if you recall, we stopped as soon as she gave the address out on Highway 10. And the second that she ended it, that she said the address, we had 2 minutes and 17 seconds left on that call. On Mr. Hogan's exhibit, we know that the call ended at 10:17:45. 10:17:45 minus 2 minutes and 17 seconds is 10:15. So because we're using this timeline throughout this trial, Bill parked in front of Tara's house at 10:17 and 26 seconds. Van Street is 400 feet long. He had almost 2 full minutes where he's driving down School Street that he knew where the location of the animals were. He knew exactly where they were. And everything he told you is that's what is most important. Now, this week, he wants you to believe that after seeing Ryelee walking, he turned down Van Street because he had to tell Tara, make sure you don't give him a ride. One of the discussions you're going to have when you go back into the jury room is what if his testimony is reasonable? To say that he would stop, and not only stop, but park out on the road instead of just driving in next to her door, hopping out saying, don't give Ryelee a ride, hop back in and go get your animals. No, he's going to park out on the street when he just saw Ryelee. He's going to park out on the street, and he's going to walk down her driveway because he said the door they use is at the back. And he told you the reason for that was he was afraid he was going to get parked in. At 10:17 at night, Monday night, school night, he's afraid he's going to get parked in. Well, at that point, if you're that desperate for your animals, drive across the lawn. He's afraid he's going to get parked in, so he parks on the street. And now he tells you, or then he told you, that he saw Ryelee running around the corner from School Street onto Van Street. And again, 400 feet long, 6 houses. Tara's house is on here. We also have the house with the Ring camera, and we have the Bricko's house. We know those houses. Somewhere in the area of the video starting, I believe it was somewhere back here. I couldn't see the stick figure he wrote, but he saw Ryelee running. Now, Bill testified he had gotten out of his car and was walking up Tara's driveway to tell her, don't give Ryelee a ride. And he saw Ryelee running down the street at him, shouting, I'm gonna get you, you MF. I'm gonna beat your ass. And that caused him such terror that he went back down the driveway to his car, grabbed a stun gun, grabbed a double-barreled shotgun, opened the double-barreled shotgun, loaded it, closed it, and pulled the hammers back, which is essentially taking off any safety. Ready to fire. Common sense, logic. If Ryeelee's running down this road and he sees him even a third of the way down the road, though he said he saw him at the corner, but the picture the defense put up, it was pitch black. Even if he saw him at the corner, by the time Bill got back, could hear what Ryelee was supposedly yelling at him, loaded his gun, and then met Ryelee. He met him right in front of the house with the doorbell camera. So all of this takes place right out here. Ryelee would have been at the car long before he ever got a gun out. And how do we explain that on the doorbell cam, Ryeelee's standing there? Now the timing that makes sense is that Ryeelee's walking down the street and he sees his mother and her boyfriend pull down the road. And all the testimony is Ryelee spends a lot of time with his mother and Bill. He's been in their car. They had already confronted him about the thefts and he was offended, but he said he didn't steal. There's no indication that he was afraid of Bill. So he's walking down the street. And the evidence is, according to Google Maps, it takes about 2 minutes to walk down the street. So where would he be after a minute? Bill parks in front of Tara's house at 10:17, and they're arguing at 10:18. 1 minute and 4 seconds. So what happened in that 1 minute and 4 seconds? I can guarantee you if Ryelee was running full blast, he would have been at the car. He wouldn't have only been halfway down the street. But if he was walking, he would have been halfway down the street. He's going to see what his mom and Bill are up to. Perfectly reasonable. And now Bill wants you to say that he was allowed to use self-defense because Ryelee was yelling at him that he was going to beat his ass. And that caused him such terror that he believed he was going to die. Because as the judge read the instructions, the only way he gets to use deadly force is if he believes he is going to die. And there has to be an unlawful interference with Bill. So as Ryeelee's walking down the street, what unlawful interference? You know where the unlawful interference is on Ryelee. He's walking down the street. You see him stop. You see Bill and Tiffany come to him, not the other way around. Bill comes to him. And you know, when I think about this case after hearing the testimony, did Tiffany know that the hammers were pulled back? Did Tiffany know when she lifted the gun and it was pointed at her son's head that the slightest pull on one of those triggers and he would have been dead? Anybody, common sense, gun safety, you don't run around with a double-barreled shotgun with the hammers pulled back. That's intent. There's the only evidence that there was an unlawful interference on Bill is his self-serving testimony this week that he had 977 days to come up with. Ryelee runs away from Bill. And when you talk about self-defense, don't forget that Ryelee had the right to defend himself. Just because he's the 18-year-old kid and it's the adult who has the gun doesn't mean he doesn't have the right to defend himself. The judge talked to you about provocation. And as he starts to read it, it gets pretty confusing. So I wanted to pull that up. I believe Bill Zelenski provoked any attack Ryelee did on Bill. Ryelee is standing on the street, according to the doorbell video. Bill confronts him. Bill told the 911 operator he confronted him. Bill confronted him and is trying to get him with the taser. Now remember Rowan? Rowan told you that before Bill left the house on East Road, he said, I'm going to tase and handcuff Ryelee. So while Bill tells you his biggest concern was the animals, I think his biggest concern was taking Ryelee into custody, because during that whole week, he was acting as a cop. He was investigating the crime. It was going to be solved on the street. He was interviewing people. He was emailing and texting everybody he knew to be on the lookout. And that night, he decided he was going to arrest Ryelee. That's what the evidence is. That's what shows on the video. Except he's not a law enforcement officer. He was separated from the force 15 years earlier. He didn't have training, and he didn't have the right. He did not have the right to handcuff Ryelee. He did not have the right to attack him and tase him. He did not have the right to point a firearm at him, much less pull the trigger and kill him. He did not have that right. In the confrontation, Ryelee never armed himself. All those weapons, that's how Bill drove around Waupaca, with all those weapons in the car. But we heard from Detective Rodans where those weapons were. There was another gun in the trunk. We saw Ryelee didn't go in the trunk. There were knives in the back seat, baseball bat in the back seat, whatever this garden tool is, in the back seat, a hammer. Ryelee went to the door of the car. He didn't get in, and as you saw, there weren't weapons within reach, and Bill was right there watching him. And Bill took the gun back from Tiffany. Now remember, he testified the hammers were pulled back. If the attack, which follows Bill's provocation, attacking Ryelee, if for some reason after that Bill reasonably believed that he was in imminent danger of death or great bodily harm, he may lawfully act in self-defense. But the person may not use or threaten force intended or likely to cause death unless he has exhausted every other reasonable means to escape. And that's Bill has to exhaust every other reasonable means of escape. What means did he have? Well, he could have driven away. The car was running, the doors were open. He could have just driven away. He told you he was afraid the car would stall. Anybody who's driven a stick shift, what happens if the car stalls? You start it up again. You close the windows, you lock the doors. What's going to happen to him in the car? What could unarmed Ryelee do to him if he's in the car? And if it stalls, just start it again. He could have run to Tara's house. He could have just honked the horn. If he just honked the horn and stayed on the horn, that would have gotten the attention of every neighbor. He could have locked the gun in the car. His fear was that Ryelee was going to get the gun from him and use it on him. And he said, I knew I'd be dead. Well, lock the gun in the car. Because Ryelee wanting to punch him in the face is not a reason to shoot him. It is not a reason to kill him. And Ryelee saying, 18-year-old kid, put the gun down and fight like a man. Sounds like an 18-year-old kid. An 18-year-old kid who says put the gun down and fight like a man, that causes a former police officer such terror that he has to shoot him, that he has to have a loaded gun with the hammers pulled back, ready to fire. It's absurd. There was just about a minute between the end of the video that showed the confrontation and the 911 call. So we don't know what happened in that minute. Tiffany said Ryelee never grabbed the gun. But you know what? It was pressed onto his skin. And you know what? If he grabbed the gun and tried to get it away from him, he has that right. He absolutely has that right. He has the right not to die. And think about Bill's explanation of the shooting and how it was Rylee's fault. Well, for one, he's experienced in firearms. You don't put your finger in the trigger. He did it because he was so terrified. Because Ryelee was trying to get the gun from him, he put his finger in the trigger. Well, if you're going back and forth, guess what? You're going to pull the trigger. That doesn't make it Rylee's fault. But when you think about the wound that's almost under his armpit. Melissa, close your eyes, please. It is almost to his armpit. And as, I'm going to take it off now. It's off. His armpit. Rylee's pulling the gun in there with two hands. One on the foregrip, one on the barrel, conveniently where DNA was found. Yeah, I believe. But this is what you would do. You wouldn't go like this. That makes no sense whatsoever. And he would have had to been leaning in because it was a downward trajectory. Bill and Ryelee are the same height. So he would have had to been down and leaning in. The gun would have had to been elevated. Two hands on it. That story makes no sense. We don't know what happened, but we know that didn't happen. Because you would go like this. Bill motioned on the stand that he was going like this. But that makes no sense because it's nowhere near there. Bill's story makes no sense. Timing is so far off. The fact that he was terrified for his life because Ryelee yelled, "I want to beat your ass." And then he tried to tell you why he was so terrified of Ryelee. Now, we acknowledge there was a domestic incident in February. And if everybody who has a domestic incident in Waupaca County could be hunted down with a shotgun, we'd have much lower population. They're not good, but they happen. But to think that a domestic incident in February means that Bill Zelenski is terrified of Ryelee in October? And every other incident that Bill talked about was Bill's own testimony. But he did testify Ryelee had never hit him, ever. They did verbal sparring. 18-year-old, I'm going to get you. Big man. Probably didn't like Bill. Probably would have wished his mother wasn't his girlfriend. Never testified Ryelee said he was going to kill him. Never testified that there was anything that would have caused him such terror. And you remember when he was talking to Officer Wazru downtown? And he's talking about, you know, the fight they had before the animals disappeared. No fear. There was no fear in his voice whatsoever. Wouldn't that be the time that it would have shown? Wouldn't it have shown in the 911 call? See, there again, he wants you to believe his police training made him so calm that he could just call, say, Ryelee was walking home, I confronted him, he came at me and I shot him. He doesn't say, he tried to grab the gun from me. Nope, he came at me and I shot him. Calm, Tiffany's calm. The one you hear is Tara, who's hysterical. The father of her grandchild is laying there and no one's helping him. And let's talk about police training. CPR, stop the bleeding, roll him over and see if he's alive. Nothing, not a thing, not a bit of aid was rendered to that poor boy. And now they want you to rule, to judge his actions and his statements and say it was all reasonable. His terror was reasonable. Well, there was no sign of that terror 977 days ago. Not a sign. Not till this week. The judge gave you instructions on credibility of witnesses. Do they have a reason to lie? Well, does he have a reason to lie? He shot someone in cold blood and killed him. Does he have a reason to lie? Mariah Bricko testified when she was looking out the window, she heard, "Stop or I'll shoot you." And then pow. That is an intentional homicide. That is not an accident. That is not self-defense. That is an intentional homicide. And to think that it was Ryelee who said that makes no sense. Ryelee never had a gun. The person with the gun was Bill Zelenski. Stop or I'll shoot you. And he did. And at the end of your deliberations, I'm asking you to find Bill Zelenski guilty of first-degree intentional homicide in taking the life of an 18-year-old boy. Thank you.
Ms. Hogan.
Accidents happen. Crimes are committed. We all know Bill didn't commit a crime that night. We know from the evidence presented in this case that Bill didn't act with an intent to kill Ryelee. He didn't act with an intent to hurt Ryelee. In the moment that Ryelee was shot, there was a struggle over that gun, and Ryelee was pulling it away, causing Bill's finger to hit that trigger. It's sad. This is a sad case. The judge is going to read you one more instruction or two. One of the final instructions tells you, base your decision not on sympathy, but on the facts. It's a sad case where an 18-year-old lost his life. We saw so many witnesses through this trial how they felt when they found out Ryelee passed away. We saw everyone's reaction trying to talk about what happened that night. Everybody who knew Ryelee, Bill included. And it wasn't just Bill on the witness stand when he broke down trying to talk about Ryelee. When Officer Rodens first told Bill, this is the first time Bill is told that Ryelee didn't make it. You saw his reaction in that video. His face was slightly behind a mask, but you saw those tears in his eyes. You saw him doing this. That's also a man who cared about Ryelee, who was devastated to find out that Ryelee didn't make it. Don't be swayed by the sympathy in this case in reaching your verdict. Look at the facts that we all heard. Everybody that you heard through about what Bill was going to do that night talked about Bill wanted the animals. Bill wanted to bring them home safely. Nobody said he only wanted to find the animals. Everybody said he wanted to find them and bring them home safely that night. Tara tells you, she testified that when Bill and Tiffany came over, they were asking about the animals. If she'd heard any information about the animals. She even told you that right before Bill and Tiffany leave, Tiffany says, if you see Ryelee, tell him we're not angry. We just want to get the animals back. Now she tries to tell you that Bill was agitated. And remember what she told you, what made Bill agitated? Daisha showing Bill and Tiffany the Snapchat video and photo. But we heard from Tiffany, we heard from Bill, we heard from Rowan that while they're still at East Road, they received that Snapchat information. That wouldn't have caused Bill to become agitated at Tara's house. It was information he already knew. She said he was calm. When he left, he was calm. Bill knew Ryelee was involved, but was still calm. All he wanted to know was where the animals were so he could go get them and bring them home safely. When he met with Officer Wazrud testified, Bill was calm. He expressed concern about the animals. He expressed concern that when finding out Ryelee might be released from jail that night, that Ryelee could go and move or get rid of or stash the evidence. And Bill would not be able to get them and bring them home safely. April testified that when Bill left, all he wanted to do was find the animals and bring them home safely. Not a single person told you that Bill was so angry, so upset with Ryelee, that he wanted to hurt him, much less kill him. Nobody testified about that. We can see in that timeline that Bill left East Road and shortly into his drive was told, avoid Mill Street. Law enforcement's already on scene. And Bill knows, hopefully law enforcement's going to get some information. So he doesn't go to Mill Street. He hangs out on Main Street for a while. Then he goes to Tara's house. And you saw there's no urgency at that time. He pulls in the driveway behind Tara, drives all the way to the back by her garage, following Tara down that driveway. Because there's no urgency at that point. He's killing some time waiting for the police to let him know some information about where these animals might be. But he's not there long because he gets that phone call from Officer Wazrud to come and meet him on Main Street. Even Tara told you on the stand that when they left, they said, "We'll be back." We know Bill was driving in the direction of Tara's house after he met with Officer Wasrud. We don't know exactly at what point in his drive from Main Street back to Van Street that he did get that phone call from Danielle. But he was driving back to Tara's house. And yes, at some point during that drive, they found out where the animals were. That was part of that priority that night. Bringing them home safely was the other part of his main priority. And so when he sees Ryelee, he doesn't even know that that's Ryelee down the road on School Street in the distance. He thinks it could be. So he turns onto Van Street, drives all the way down, and parks in front of Tara's house. Because he's going to tell Tara, don't give Ryelee a ride. If that's Ryelee and he's going to come over here, don't give him a ride. Because Bill knows, Ryelee now knows where these animals are. And if he's going to be released from the jail and come get these animals, there's going to be a confrontation at Angela's house. And Angela said to Bill and Tiffany, I don't want any trouble. I don't want the police over here. They were over here earlier. Don't bring any trouble. I don't want any trouble here. So he parks on the road because he is just going to run in and tell Tara not to give Ryelee a ride. Ryelee got a ride everywhere. Ryelee didn't have a driver's license. Ryelee didn't have a car. He got rides everywhere. From Madison, from Mackenzie, the daughters of Tara, who could be at Tara's house. Tara doesn't know where these animals are. And the state, in cross-examining Bill, said, well, it would be obvious that Tara wouldn't give Ryelee a ride to Angela's. Why? Tara didn't know the animals were over at Angela's. It wouldn't be all that strange for Ryelee to come over and ask for a ride. And in closing, the state tried to get you to believe that Bill's testimony was he got out of his car after he parked and he was walking down Tara's driveway. But that's not what Bill told you. Bill told you he got out of his car and started to walk towards Tara's driveway. Didn't even make it to Tara's driveway, and he sees somebody off in the distance running at him. He doesn't know who that is until Ryelee speaks and is yelling, I'm going to get you, which is the same thing that he told Bill right before Bill's firearms went missing. When Bill saw Ryelee running down the road at him, threatening him, the state keeps telling you, well, Ryelee was unarmed. We know Ryelee was unarmed. He didn't have a weapon on him. Bill believed he could have a weapon because Ryelee had stolen guns from him. Ryelee could have other weapons on him. Bill told you, in his experience, if you get brought to the jail and you have weapons that you're legally allowed to have, knives, and you're released, they're going to give them back to you. There's no reason for the police to hold on to your knife if you're going to be released, and you can legally have that knife. So as Rylee's charging down the road at Bill on this dark street, Bill has no idea that Ryelee could be unarmed. He believes Ryelee is armed. That's why he goes back to his car and he gets that shotgun. Because Ryelee can be armed, and if Ryelee has a weapon, he's going to get Bill. Those are Rylee's words. And all of the prior experience Bill had with Ryelee, seeing Ryelee chase Mackenzie, knowing that he beat up Mackenzie, got into fights at the jail, threatened him, threatened Tiffany just days before this incident. That's why Bill grabs his gun. Tiffany had got out of the car, and they're on the road, seeing Ryelee come at him. He's not walking. Nobody said that Ryelee was just walking down Van Street. Because where he was when Bill saw him was down School Street. And the state presented evidence that to walk the distance of Van would take 2 minutes, more than 2 minutes if Rylee's down School Street. But Rylee's there in just over a minute because he's running down School Street, running around the corner, and running directly at Bill. Even Tiffany testified to that Ryelee was running down the road. So he gets the gun in an attempt to stop Ryelee. The state told you Bill testified when he grabbed that gun, he loaded it and pulled the hammers back. That wasn't Bill's testimony. Bill's testimony was, I don't remember when the hammers were pulled back. He didn't say, I grabbed that gun and I loaded it quick and I pulled the hammers back. No, he didn't do that because he wasn't intending to use that gun. He wasn't intending to shoot Ryelee. He was intending to stop the threat that was barreling towards him. And the sight of a gun would hopefully stop Ryelee from advancing towards him. We saw that use of form sheet that the state presented. Simply displaying a firearm is use of force that can hopefully stop a threat from coming towards you. And so Bill got his shotgun and he approached where Ryelee was running at him. Hopefully, Ryelee would stop. And at some point, he did stop on the street, right in front of Joseph Brown's house. And that's where the video starts. But Ryelee didn't just magically appear standing in one spot. He was running down the street at Bill, and Bill was trying to stop any more advancement coming towards him. And Ryelee was looking to fight. We heard Ryelee several times, put down the gun and fight me like a man. So when Bill and Ryelee are close, we see this video. We're going to play it one more time for you. And watch. Ryelee doesn't have his jacket on. When he takes his jacket off because he wants to fight Bill, Bill told you at that moment, I thought it was unlikely that Ryelee had any sort of weapon. So what does Bill do at that point? When he now believes Ryelee may not be armed, he gives Tiffany the gun and gets his taser. Because now he knows, now I really don't need to use this gun. I never wanted to use it. I never intended to use it because I don't want to kill Ryelee. I just want to stop him from coming towards me. So that's why he takes out his taser and attempts to subdue Ryelee. And it's not until Ryelee runs to the car. And remember the testimony? Rylee's been in Bill's car before. Ryelee knows all of these weapons are in Bill's car. Knives scattered about his car, in the center console, near the ashtray, in the passenger side area, in the glove box. There's weapons in the back seat. It's not until Ryelee runs back to the car where he knows there's weapons, Bill knows there's weapons, that Bill gets the gun. But he doesn't go up to Ryelee and point the gun at Ryelee because he can see Ryelee doesn't grab a weapon. And when Ryelee gets away from the car and starts coming at Bill, put down the gun and fight me like a man. We see that Bill's not pointing the gun at him because he doesn't want to use it. We see Bill backing up, having the gun pointed towards the ground, just like we can see. Now, the other important thing that we saw in this case is the positioning right at the end of that video and the beginning of the next. On the left of your screen is the very end screenshot of the video right before the shot rings out. And on the right is the screenshot of the very start of the next video. And I want you to look and I want you to pay attention to where Bill is standing before that gunshot and where Ryelee is after the gunshot. Bill didn't go towards Ryelee. Ryelee came at Bill. Ryelee came at Bill and the gun went off. Those were Tiffany's words. Ryelee came at Bill and the gun went off. And we know, even though Tiffany said, I don't think Ryelee grabbed the gun. She says, I think I saw the gun the whole time. But she even admitted on that stand that when Ryelee went at Bill, Ryelee's back was to Bill. Or Ryelee's back was to Tiffany. Tiffany couldn't see his arms. Tiffany couldn't see the gun. Tiffany didn't see what Ryelee and Bill were doing with the gun. Because Ryelee came at Bill, grabbed that gun, and tried to pull it away from Bill. The state wants you to believe that it's absurd, or it doesn't make sense, that Ryelee would have been reaching for the gun and pulling it when it went off. But we saw that. We saw with a gun that Officer Rodens told you had the same measurements as the shotgun used in this case. And this blue tape is the exact location where the foregrip was on the shotgun, and this blue tape was exactly where the flashlight was. And when we had Dr. Kovac on the stand, he told you, if somebody's leaning forward and pulling the gun, that this position is consistent with the injuries that Ryelee had. Because this is moderately downward, it's front to back, and left to right. It's the exact trajectory of the BBs. That's what Dr. Kovac told you. The state wants you to believe that Ryelee was on his knees with his hands up in the air when Bill shot him. In that video that we saw, we know that the shooting happens and Bill is able to get the phone and speak to 911 in an exact minute after that video ends. As Rylee's trying to come towards Bill, saying, put down the gun and fight me like a man. And the state wants you to believe that Ryelee went up to Bill, said, okay, Bill, I give up. That's what the state wants you to believe. Because that's the only other way that Ryelee gets the injuries that Dr. Kovac told you about. That doesn't make sense.
There's the facts, not in evidence.
Or argument.
It's argument. Proceed.
in her opening statement, the state told you the gun was in a downward trajectory. And imagine the positions of the body that it would have to be in. There's no other way Ryelee gets those injuries with that trajectory unless he's either on his knees or grabbing the gun and pulling it towards himself. Which one is consistent with that video that we saw? We know that that's what happened because it's consistent with the neighbors, Mariah and Nathaniel Bricko. The only people that you heard in this case that have no connection to Ryelee, except the officers and the experts. All the other citizen witnesses that you heard from have some sort of connection to Bill or Ryelee, but not the Brickos. And what did Nate Bricko tell you? That he looked out, he turned on the light, and we even saw in those screenshots, it was a little bit lighter because that was the Bricko's front porch light that came on. And he says when he looked out, he saw what he initially described as a struggle. He then said, well, maybe it wasn't a struggle, but they were definitely close. It looked like they were touching. Because from his distance, seeing Ryelee and Bill struggling over that weapon and pulling it, that's what he saw. That's the struggle that he was describing in his written statement. And Mariah told you in her written statement that she heard very clearly, I'm going to shoot you if you don't stop. If Bill intended to kill Ryelee, why is he saying that? He's saying that because Ryelee came up to him, grabbed the gun, they're struggling, and Bill said, if you don't stop, I'm going to shoot you. That's what Mariah said she heard very clearly. And right when Nate saw that struggle and they heard a mention of a shooting, Nate said he immediately turned, went inside, grabbed his son, and under a minute later, he heard a muffled gunshot. Because that was Ryelee pulling the gun into himself, causing the gun to go off. Those are the only witnesses that don't have a connection to Ryelee or Bill. They can be believed. Other injuries are consistent with Ryelee pulling the gun away from Bill, causing it to go off. Remember the state introduced evidence of Bill's finger and how Dr. Kovac told you that that would happen? If Bill's finger isn't, or if the butt of the gun isn't against Bill's shoulder and the gun kicks back and it hits your finger, that's what could cause the injury to Bill's finger. Just like when Ryelee reached, grabbed it, and was pulling it, the butt of the shotgun came away from Bill's body, causing his finger to hit that trigger, discharging the gun, causing the trigger guard to go back onto Bill's finger. There's no other way that Bill's finger gets injured in that way. Also consider, if Ryelee is on his knees when he gets shot, we saw the image of Ryelee forward. But if he's straight up and down and gets shot, and the force of that shot, where is Ryelee going to go? He's going to go this way. But that's not what we saw. Because Dr. Kovac told you if Ryelee grabbed the gun, pulled it, got shot, he could fall straight down. Just in the exact position that we saw. It's consistent with the DNA evidence. How does Rylee's DNA get on that foregrip unless he grabs it? His DNA is located in that mixture with the highest likelihood ratio that the state laboratory has. Rarer than the entire world's population, 1 in 7 trillion. We know that's Rylee's DNA on that foregrip, because there was so much of that DNA when he grabbed it and was trying to pull the gun away from Bill. Kevin Scott told you that when there's friction and pressure applied, that's when you're going to leave more DNA behind, as Ryelee did when he grabbed it and was trying to pull it. Why doesn't Bill assist Ryelee? Bill told you he thought Ryelee was still a threat. Tara told you when she came running outside, she saw Ryelee on his knees with no blood. She thought Ryelee was faking it. She didn't think Ryelee had actually been shot. She thought Ryelee was faking it. And if she thought Ryelee was faking it, what about Bill? This is a person who just said, put down the gun, fight me like a man, came at Bill and grabbed that gun. If he gets up, he's still a threat to Bill. So Bill does what he believes to be the best. Get that phone, call 911, and get them there as soon as possible, which is exactly what he does. Yes, Bill did not try to render aid to Ryelee, as the state just pointed out in their close, and you heard Dr. Kovac tell you, that wouldn't have saved Rylee's life. It wouldn't. Don't think that the failure to run over to Ryelee and try to render aid means that Bill's guilty of intending to kill Ryelee. Bill did exactly what you would expect if he did believe Ryelee was a threat, to still maintain some distance from him and talk to 911. Officers told you, not just Bill, other officers told you that the #1 priority when they respond to a situation like this is to secure the scene. Because if there's still an active threat, you're not going to be able to perform aid if there's still a threat for an attack on officers or others. That wasn't just Bill who told you that. That was officers. Current police officers told you, #1, always make sure the scene is secure. And if Rylee's still a threat to Bill, it's not secure. Remember, we heard from Officer Shabelsky. He told you that this was the second day on his own. He was not even 3 months into being a sworn police officer with Waupaca Police Department. Had just got done with field training officers. This was his second shift on his own. His first emergency call he ever responded to on his second day on his own. And what did Officer Shabelsky do? He remained calm. Because he told you why that's so important for people to remain calm, to provide details, to make sure officers know of the information they need so that rescue can come, additional officers can respond. Bill remained calm because that's what he was trained to do. Just like every other officer who responded. That doesn't mean Officer Shabelsky, his heart wasn't racing. His adrenaline wasn't going. It probably was. But he knew he needed to control that and remain calm for everybody. We also know Bill's mind that night was clear. He didn't have any alcohol in his system. He didn't have any drugs in his system. He had some nicotine and he had some caffeine. But Ryelee was on meth. And we heard Dr. Kovac tell you what meth does to an individual, and Officer Grant tell you what meth does to an individual. Impulsive, unpredictable, violent, aggressive. That is exactly the Ryelee we saw in that video. Aggressive, unpredictable. When he lunges towards Bill and grabs that gun, something Ryelee never would have done had he not been on meth. He was unpredictable. State wants you to believe couldn't have been an accident. Bill never said it was an accident, that Ryelee pulled the gun and the gun went off. But if Ryelee pulled that gun and Bill's finger did hit that trigger, in that moment when everything happened so quickly, Bill's number one thought is, my finger hit that trigger. I shot him. I had that gun. I shot him. He came at me. I had to do it. Those were Bill's words. You never heard Bill's words saying, I wanted to kill Ryelee. I'm glad I killed Ryelee. He never said any of that. Tiffany told you Ryelee went at Bill and the gun went off. Tiffany told you in those words that it was an accident. The state tried to also show you all of these text messages from Bill's phone, showing how he intended to kill Ryelee, where he said, I'm hunting down thieves. He also said, I'm working on some paperwork, hunting down the third. He's not telling somebody he's going to get his gun and drive around hunting down somebody. It means I'm trying to find out who took my animals so I can get them and bring them home safely. Whoever took them signed their own death sentence. Because whoever took them, Bill knew, didn't know how to properly care for them or handle them. And they were venomous. They were going to bite that person and kill them. That's what he meant by signing their own death sentence. Not, I'm going to go kill whoever found my animals. Because we never heard any of those messages because they didn't exist. Solving it on the streets. It's exactly what Bill did. He was going around on the streets trying to find information. Just that night, he went to Tara's house to try to get more information at that time about his animals. There's no text messages on Bill's phone. I'm going to kill whoever did this. I'm going to kill Ryelee. I found out Rylee's involved. I'm going to go kill him. I'm going to shoot whoever did this. There's no threats. How many of us have gotten so upset we've said, I am so upset I could kill you? That wasn't even Bill's words. Bill never even said anything near that because he wasn't so upset he wanted to kill somebody. He was trying to find his animals and bring them home safely. I also want you to think about this. If Bill intended to kill Ryelee, what sort of evidence do you think we would have seen in this trial? If Bill had that gun, when he got out of his car and he was close to Ryelee earlier before the video kicked on, if he intended to kill Ryelee, why didn't he shoot Ryelee right then and there? Because he didn't intend to kill Ryelee. He didn't intend to use the gun. He didn't want to use the gun. If Bill intended to kill Ryelee, why was the gunshot in his right armpit? If Ryelee was on his knees when Bill shot him, why would Bill deliberately go to his right armpit and shoot him? Ryelee wasn't shot in the head. He wasn't shot in the back. He wasn't shot directly in the chest. If Bill intended to kill Ryelee, why would he intend to shoot him in the right armpit? If Bill intended to kill Ryelee that night, you heard, this is a double-barrel shotgun. 2 triggers. Both barrels are loaded. The same trigger or trigger area. 1 trigger for the left barrel, 1 trigger for the right barrel. If Bill intended to kill Ryelee, why wouldn't he shoot him a second time? Because he didn't intend to kill Ryelee. When the shot went off and Ryelee let go of the gun and fell down is when Bill backed away. Because he didn't intend to shoot him. He didn't intend to kill him. If Bill intended to kill Ryelee, why immediately call 911 as soon as he could? As soon as Ryelee was shot, Bill asked Tiffany, "Where's my phone? We need to call 911. Tiffany had just had his phone. They get in his car, they find the phone, she dials it, hands it to Bill, and he's immediately talking to 911. Why? If he intended to kill Ryelee, if he wanted Ryelee to die, why would he call 911 at all? Why wouldn't he sit around and wait to call 911? Tara told you as soon as she came outside, Bill was on the phone with somebody. If Bill intended to kill Ryelee, why wouldn't he just jump in his car and leave? And just leave Ryelee there? Because he cares for Ryelee. He didn't intend to shoot him. He didn't intend to kill him that night. State tries to argue to you that Bill testified about all of his officer training, yet he was terrified of Ryelee. As though police officers can't get scared in situations. When we were here for jury selection, a lot of you indicated, I could never be an officer because of the situation that they have to put themselves in. We all know officers, despite their years of training and experience, get scared in situations. As the judge told you, Bill doesn't need to prove his innocence. The state is bound to prove Bill guilty beyond a reasonable doubt. There's a reason that Bill's on this side and the state's on this side. Because over here, Bill starts with the presumption of innocence. And the state wants you to find Bill guilty. Imagine there's a river flowing right between these two tables. Raging river. The state, in order to get Bill from innocent to guilty, needs to build a bridge. A bridge of evidence that you can hoist Bill on your shoulders and cross over that river to their side. That evidence needs to convince you beyond a reasonable doubt that Bill's guilty. The judge also told you that if you can reconcile the evidence with any reasonable hypothesis consistent with Bill's innocence, you should do so. And Ryelee reaching at Bill, grabbing that gun and pulling it isn't just a reasonable hypothesis in this case. It's consistent with the DNA evidence. It's consistent with Dr. Kovac's testimony. It's consistent with the neighbor's testimony. It's consistent with the video that we all saw. It's consistent with that timeline that you saw we put together as this trial went on. It all points to the same conclusion. It's not just a reasonable hypothesis. It's the truth of what happened. That Ryelee came at Bill, grabbed that gun, and the gun went off. It was an accident, not a crime that Bill committed that night. That's why I'm asking you, during your deliberations, ignore the sympathy and the emotion that all of us feel on this case. Look at the evidence that's been presented and look at the truth of what happened after that video goes off and return a verdict of not guilty. Thank you.
We are late for taking our morning break, so we will take a break at this time. Ms. Ishwood, any idea how long your rebuttal is going to be?
Mr. Sledge is gonna do it.
But we're more concerned right now that it was that self-defense wasn't brought up in the closing argument.
It's up to the jury.
It's
They've
up to the
heard
jury.
evidence
They-
throughout the trial that it could be self-defense.
But to the actual shooting itself, there was no evidence that there was an intentional use of force. And no argument that there was an intentional use of force.
The jury's been instructed. I think the facts that have been adduced could be found to support the instructions. I know we probably didn't make a clear record, but I had concerns about some inconsistency of the instructions, but there's nothing that forbids the defense from having multiple theories of defense. It's primarily the state that needs to be consistent in its analysis. So,
There were no multiple theories advanced in the argument.
and it's completely up to the defense the type of argument they want to make in closing. They don't have to do anything. They can stand up and say, the state hasn't proved its case. Find not guilty. They don't need to say why they should be found not guilty. Any objection to that argument is overruled. You have a legitimate argument. If not, how long is your rebuttal going to be?
Well, I haven't timed it, so
Just an estimate. I want to be able to tell them when to order lunch.
I would say probably less than 20 minutes.
Okay, so we could have lunch early potentially today. All right, we will recess. Well, if they bring be seated. Take it we're ready for the jury.
Yes. Yes.
Sure, you want that marked? I don't think it needs to be marked. It can just be. Please be seated. Mr. Slodgy, you may proceed.
Ladies and gentlemen, I will make this as brief as I can. There's was a lot of discussion by Attorney Hogan about Bill didn't intend to kill Ryelee, right? That he didn't tell anyone he wanted to hurt him or kill him. If he wanted to kill him, why didn't he shoot him various other places or multiple times? But the other, in defining what is intent, one half, which attorney of the definition, or one possible definition Attorney Hogan focused on, is the mental purpose to take a life. Another definition is, was the defendant aware that his conduct was practically certain to cause death? Keep that in mind. We heard that on the 19th, that Bill was going to 400 Mill Street when he was stopped by law enforcement. But if he hadn't been, who did he expect to find there? But Ryelee Manente Powell. The same person who he's so scared of. After there was Attorney Hogan said after he knew about the location of the animals, he was still concerned that if he went there, if Ryelee showed up, there'd be a confrontation. But what reason did he have to believe that? That day, Bill had no contact with Ryelee before what happened shortly before shooting him. There were no messages exchanged. He had no reason to believe that Ryelee was going to be violent with him or tried to be. When you heard Attorney Hogan talk about when Ryelee removed his jacket, at that point, Bill became more convinced that he was unarmed, so he was willing, or chose to give the gun to Tiffany. But we've seen this video, and so I won't play it again. What does Bill say to Tiffany? Hold this on your son. Hold this on your son. Hold what? A loaded shotgun with the hammers cocked, ready to be fired. Sure seems like it was an option, right? Hold it on your son. Bill also, there was a lot discussed about his, there was no substances found in his blood, right? He was of clear mind. That's what his attorney said. So he was of clear mind when he chased after Ryelee towards the car. When he took the gun back from Tiffany. When he retreated, which as we know on the video is, if that's a retreat, it was maybe a few steps backwards. He was scared, he said, that Ryelee could arm himself with. If Bill took 5 steps backwards and held the shotgun towards Ryelee. If Ryelee came at him with a baseball bat, a knife, a a hoe or a hammer. At that point, certainly a shotgun, double barrel 12 gauge, could have pretty easily overcome that. But that's not what he chose to do. He chose to get closer. Again, Bill's mind was clear. Stop or I'll shoot. His mind was clear when he put his finger inside the trigger guard. So there's a tussle over the gun, it's being pulled back and forth. His mind's clear when he puts his finger inside that trigger guard. Inside of a loaded, ready-to-fire shotgun. His mind is clear when he calls 911 and says that he confronted Ryelee. Ryelee came at him, and I shot him. He says, well, if Tara, Attorney Hogan said, if Tara didn't know if Ryelee was faking it, then how would Bill? But what we know is that Bill was the one holding the shotgun that was pushed into Rylee's chest. He was the one holding the shotgun when it discharged into him. So how would he know? It's not a tough question, because he was the one who shot him. From just the length of that shotgun. He then claims and wants us to believe he was still scared of Ryelee. And that it's an officer's priority to clear the scene. Again, he still wants us to believe that somehow he's following law enforcement training and yet not at the same time. Earlier, when he still thought Ryelee was a threat, what did he do? He gave the gun to Tiffany and then approached with a taser. So if he's still, even if we can give him that benefit of the doubt, that Ryelee was maybe still alive and he was still concerned about whether he would get up and pose a threat, why didn't he do the same thing? Say, Tiffany, hold this. I'm going to go to Ryelee. Because he didn't know he was dead. Yes, Dr. Kovacs told us that. But that's a doctor. That's a medical examiner. That's after performing an autopsy and seeing all of the catastrophic damage to Rylee's lungs, his heart. Bill didn't know that. But he did nothing to try to find out. So we can sit here today and tell you that it would have been ineffective. But that's not what he knew then. Bill also wants us to believe he was devastated about Rylee's death. Because we saw him cry on that body camera, right? When he first learned about it, that he was dead. So apparently, shooting him in the chest, that's no big deal as long as he pulls through. The only reason he has to be upset is if he's dead. Ignoring the testimony that Bill actually saw the search warrant at the hospital that said the charge was first-degree intentional homicide. Bill, a former police officer, is going to try to have us believe that he didn't understand that that meant someone was dead? And who else would be dead that he would be being investigated for, if not Ryelee? He knew. Again, intent is if you are aware that your conduct is practically certain to cause death. Bill loaded that gun, and whether he cocked the hammers when he got it out of the car or when he took it back from Tiffany, he testified that he knew they were cocked. So when he knew when he was struggling with Ryelee, if that's in fact what happened, that if he put his finger in the trigger guard and Ryelee pulled that gun, his finger would pull the trigger. Practically certain. The last thing I want to stress, and this is from the instruction that you were given about reasonable doubt. And while it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt. You are to search for the truth. And I think the truth has been pretty clearly laid out before you today, this week. Thank you.
Now, members of the jury, the duties of counsel in the court have been performed. The case has been argued by counsel. The court has instructed you on the rules of law which should govern you in your deliberations. The time has now come when the great burden of reaching a just, fair, and conscientious decision in this case is to be thrown wholly upon you, the jurors, selected for this important duty. You will not be swayed by sympathy, prejudice, or passion. You will be very careful and deliberate in weighing the evidence. I charge you to keep your duty steadfastly in mind and as upright citizens to render a just and true verdict. You are to decide only whether the defendant is guilty or not guilty of the offense charged. Any consequences of your verdict are matters for the court alone to decide and must not affect your deliberations. The following three forms of a verdict will be submitted to you concerning the charges in this case. One reading, we, the jury, find the defendant William C. Zelenski guilty of first-degree intentional homicide as charged in the information. A second reading, we, the jury, find the defendant William C. Zelenski guilty of second-degree intentional homicide. And a third reading, we, the jury, find the defendant William C. Zelenski not guilty. It is for you to determine which one of the forms of the verdict submitted you will bring in as your verdict in this case. This is a criminal matter, not a civil case. Therefore, before you, the jury, may return a verdict which may be legally received, the verdict must be reached unanimously. In a criminal case, all 12 jurors must agree in order to arrive at a verdict. When you retire to the jury room, select one of your members to preside over your deliberations. The presiding juror's vote is entitled to no greater weight than the vote of any other person or juror. If you need to communicate with the court while you are deliberating, send a note through the bailiff signed by the presiding juror. To have a complete record of the trial, it is important that you communicate with the court only by a written note. If you have questions, the court will talk with the attorneys before answering, so it may take some time. You should continue your deliberations while you wait for an answer. The court will answer any questions in writing or orally here in open court. When you have agreed upon your verdict, have it signed and dated by the person you have selected to preside. After you have reached the verdict, A presiding juror will notify the bailiff that a verdict has been reached. Everyone will return to the courtroom. The verdict will be read in open court, and the court may ask each of you if you agree with the verdict. As you may have noticed, I indicated there have to be 12 jurors in agreement, unanimity. There are 15 of you here today. We had the extra jurors in case something were to happen during the week of the trial where life intervenes and someone could not sit and deliberate and be a member of the jury. We have randomly drawn 3 of you who will be excused from deliberations. I want to thank those 3 individuals with my deepest gratitude for taking the time to be here. I'd encourage you, if you desire, to sit and listen to the ultimate end of the trial. And it is even possible, if something were to happen during the deliberation process where someone couldn't serve, one of you, the 3 of you might still even be called to join the jury. Deliberations would have to start completely anew, and that's a highly unlikely circumstance, but the 3 of you which are being released now have really performed a very important purpose, so I want to expressly thank you. So you want to you want me to announce them?
Your Honor, given the circumstances of this trial, is it your instruction that the alternate should avoid the media?
It would be my instruction that you avoid the media until a verdict comes in from the jury as a whole. But obviously, once a verdict has comes in, as I told you earlier, all of my admonitions about not talking with family members or anyone about the case are all lifted. You can talk with anyone you want after the jury verdict comes in. The 3 that are being excused are going to be released back to the jury assembly room. Your lunches will be delivered to you there. The other 12 of you will go back into the jury room, but we need to have those remaining, the officers sworn at this time. So the bailiffs.
Please raise your right hand. Do you swear that you will, to the utmost of your ability, keep all jurors sworn on this trial together in some private and convenient place, subject to the direction of the court until they have agreed on their verdict or are discharged by the court, and that you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict they have agreed upon, so help you God?
I do.
Okay, the 3 of you that are being released right now, if you have items in the jury room, why don't you retrieve those right now, and then you can go to the jury assembly room and get your lunch. Will be a little while. We ordered it, but it's not here yet. Okay. Here is.
Here, one of them asked, can I just go home?
Technically, after they eat, yes.
We could let the bailiff know.
Can also indicate that apparently some of them were concerned if after deliberation starts, if I'd allow them to have nicotine breaks. And I said, if they really need it, I would allow it. We'll bring everyone in here and those who need to take the break because they can't continue to deliberate with anyone missing. So that's how I advise the bailiffs. We will handle that issue. Do you have an the verdicts? I'll use this thing. So the excused ones are out. Okay. Members of the jury, enjoy your lunch and start your deliberations. You can work right through lunch. Thank you. Please be seated. We are outside the presence of the jury. I don't know if counsel have any thoughts about exhibits. It's the court's thought that perhaps we not send any exhibits in unless they are specifically requested, particularly since some of those exhibits are dangerous weapons.
I would wholeheartedly agree with that.
But I think if they ask for specific exhibits, we will probably give them to them, or we'll address it at that time. But I think they've seen most of the exhibits, and some of the exhibits will be hard because they're electronic exhibits. It's not easy to send in. So absent a request, I'm not sending any in unless someone wants any particular exhibit to go in.
And Your Honor, I would suggest if they wanted to see something electronic, that we do it in the courtroom.
We bring them in and show it here.
That all makes sense to the defense as well.
Okay. I assume you will probably be in your office.
I will.
Do you have a phone number that you want us to call, or do you know where you will be?
I did provide my phone number to the clerk.
You still have it? You same number?
Yes.
All right. Then we will recess. Please be seated. We will go on the record. We are outside the presence of the jury. The appearances are as have been noted throughout the trial. We do have a question from the jury. May we see the gun and the video in slow motion just before shooting?
Is that appropriate?
I would guess that it is. If someone could pull up that video and play it in slow motion, whoever has that ability. Now, what's not clear, if they want to see the gun proper, I'll have to clarify that because I don't necessarily want to send the gun into the jury room.
I would ask that an officer take it.
Yeah, a police
Yeah.
officer take it in.
Well, that I just need to clarify what
Yes,
that
okay.
means. But otherwise, we're ready for the jury.
Or if we
I'll wait.
just show the jury, like.
The gun in here, that's why I just want to find out what they want. Please be seated. I have a note signed by Mariah Floysted. The video in slow motion just before shooting. So, Ms. Floysted. Okay. I'm going to ask an officer then to bring the gun up and exhibit it to the jury, please. And Shane, why don't you slide down? There's some on the other end who are having a difficult time seeing. In just a minute, I want everyone to see it first. Now you asked about asking questions. What type of question are you seeking to ask Ms. Floysted?
I believe we kind of want to know how the gun works, because some of us aren't familiar with guns, and being that there's 2 triggers, how that works.
There was testimony that would have certainly covered those issues. You also wanted to see some video. Why don't we show you the video and then we'll see if we can give you some type of summary on how a gun works. But can you play the video then in slow motion? that the video the jury was looking to see?
Do they need to see it again?
No.
Okay. What, I'm going to ask that you yes, sir.
I want to know on the shotgun, there are two triggers and which barrel was fired and which trigger controls which barrel, or forward or backward.
We will talk about what we can advise there.
If we could just have a moment.
Sure. And just so we have a clean record, sir, I'm sorry, what was your name? The jury, I will advise you that the trigger that fired was the back trigger and that fired the left barrel. If you need more description of how a gun operates, we do need to take a recess so we have some experts who could probably make a more concise explanation. Is that adequate or do you need more information?
No, that's good. That's that.
All right, thank you. You may resume deliberating.
Thank you.
Please be seated. I guess we will go back into recess waiting for a verdict. No, actually, let's go back on the record. May as well raise an additional issue. Court TV has a letter, I think that's been provided to counsel, asking that once the verdict's in, if there's any objection, giving it to the jury. I'm going to tell the jury when we're done, they're not limited in what they discuss or with whom they discuss. Does anyone have any objection to them receiving a copy of this letter in their jury room?
The state doesn't.
No.
So we will allow the release of that letter after the verdict is in.
Can we just have a copy of this letter for the court file, just in case?
Yeah, there should be one in the court file, so.
I had one, but it disappeared.
I removed it from your desk.
Okay, but no, it should be part of the court record. I agree. Thank you. We will recess then. Please be seated. We will go back on the record outside the presence of the jury. Counsel, the jury has sent another question. Need more clarification on quotation marks, not actually, and quotation marks, not reasonably. The paperwork is a bit confusing.
We can all agree to.
That was my observation. I was,
Find where in the jury instruction?
I don't know, there's several places. My guess is it may be within the elements of second degree. Well, it could be any place within 1014 where it does talk about not actually and it does talk about not reasonably. I was thinking we might just tell them they've got the instructions, they should read them. The common understanding of the words not actually is the interpretation, and then the words not reasonably, they can look if they need further description of reasonable in other places, but they're common English phrases. I don't know if counsel want any further.
If I could just take a minute, I'm looking for the not actually language and where it is in front.
Okay, well, it's in several different places, but they're, where was it? It's contained within the actual belief that force used was necessary in the state. This records the state to prove either the defendant did not actually believe he was in imminent danger of death or great bodily harm, or two, the defendant did not actually believe the force used was necessary. And I think it's in another spot. It's actually obviously in the elements of first degree, element 3. And but those phrases are used several places within the instruction.
I guess my thought is that
reasonably, a reasonable belief can be a mistake, but I don't know how to define it without.
Can we find where in the I know there's somewhere in here where reasonably is defined. We could point them to that.
Okay.
Page 2, determining whether beliefs were reasonable.
Well, within 1014, above jury decision is the description of reasonableness. The reasonableness of the defendant's belief must be determined from the standpoint of the defendant at the time of his acts and not from the viewpoint of a jury now. The standard is what a person of ordinary intelligence and prudence would have believed in the position of the defendant under the circumstances existing at the time of the alleged offense.
I guess, Your Honor, I think
Just pointing them to the pages, well, I don't know if the courts are numbered, but there is within the instruction after intent and motive on the next page, actual belief that forced use was necessary, and then
I think
right after the elements of second degree, there is, well, actually within it, right after the elements, there's a paragraph, reasonable belief that forced use was necessary, and I think it probably defines it as well as we can give it to the jury.
So we tell them to read the entire instruction and it's in there.
That's what I think. Read the instruction. The language is in English. we acknowledge it may be difficult to understand, but it's defined in the instruction and they need to interpret it.
At least reasonable is, yes.
Well, and then actual is, actual did not actually believe, I think is a self-evident context. It was made up, for instance. I mean, did you believe him? I think that's for them to decide. But I don't know.
Can you tell them, did you believe him?
Well, why don't we take a recess? Do council want to talk about this for a minute? Maybe council want to come up with some statement?
I mean, my opinion is we just tell them they have the instruction and those terms are used and potentially defined on how to use them within the instruction. And
That was what I was planning on doing, but I don't know how else to do it.
And I think maybe if we point them to certain
Places in the instruction,
But the language is used multiple places within the instruction.
I think we should just remind them to read
Read the entire instruction.
and then go back to the
Yes,
portions.
I think so. Okay. Please be seated.
Your Honor, the foreperson handed me the paperwork and she asked if she could bring it in with her.
Sure. Members of the jury, you asked for a clarification of, you put parent not actually closed parent and parent not reasonably closed parent. And you indicate the paperwork's a bit confusing. I'll be the first to say that I think it can be confusing as well. First of all, though, the instructions you have define the law that you are supposed to apply. So read the instructions in their entirety. And there's, it's not in Latin, for instance, it's in English. So use your common knowledge of the language and what's written to try to answer your questions. I don't know what to tell you much beyond that because the instructions you've been given define the law that you are to apply in Wisconsin. And I see the foreman, you're making a face. Did you have a specific question?
We're all confused about just the wording of it, I think, is what's throwing us off.
Well,
We have highlighted, I don't know, if we can give you guys the paperwork to look over first to see what we're questioning.
well, sure. Thank you. The paperwork that has been highlighted includes the third element, the first degree intentional homicide, and what's highlighted is not actually with actually underlined. Then additionally highlighted and sort of bracketed is all of the description about actual belief that the force used was necessary. Then also highlighted is in the second degree intentional homicide, the third element that has been highlighted, not reasonably, with the reasonably underlined. And then again, the bracketed section about reasonable belief that the force used was necessary. I would suggest, members of the jury, that you read those sections again. And I don't think there's any unique legal definition of actual. Read what it and make your findings based on that. Now, reasonable is defined in more detail within the instruction. So you should read the instruction as a whole to answer your questions. I wish I could give you better guidance than that, but it's not easy. So, thank you. Good luck. Again. Please be seated. We are ready for the jury. Please be seated. Members of the jury, I understand you may have a verdict. Please give it to the bailiff. Thank you. I have a verdict reading as follows. We, the jury, find the defendant, William C. Zelenski, guilty of first-degree intentional homicide as charged in the information dated at Waupaca, Wisconsin, this 23rd day of June, 2023, signed by the... Is that, in fact, the jury's verdict? So say you all?
Yes, Your Honor.
Do you wish to have the jury polled?
Yes, Your Honor.
Do you want to do it? You want me to do it? Mary Jo. Members of the jury? Yes. Thank you, members of the jury. We truly appreciate your commitment of time and your attention in these matters. As I told you a week ago, I knew that serving on a jury interferes with your lives. It disrupts your daily life. I know it's a burden, but it's a burden taken on by people such as yourselves that makes ours the best jury system in the world. I did previously admonish you that you could not talk with anyone about this case. That admonishment is now relieved. You can talk with anyone about anything in the case. However, you are not obligated to. If anyone is harassing you, for instance, and you don't want to speak with them, tell them the court says I don't have to. They have ways, if your testimony were to be needed, to get you brought back into court. But you are free to talk to anyone about anything that's happened here. Thank you for your service. Please be seated. I will receive the verdict at this time.
Your Honor, the state would move for judgment on the verdict.
And the defense would ask for a judgment notwithstanding the verdict, Your Honor.
Well, as I indicated, I will receive the verdict at this time. I will at least now deny the request for judgment notwithstanding the verdict. I can set the matter for motion hearings if counsel desire. Otherwise, I take it we need to set the matter for sentencing.
That's correct.
Is there going to be a request for a pre-sentence investigation?
Not by the state.
I think given the circumstances, it wouldn't be a bad thing to have for the court, particularly to determine the potential for eligibility at release.
Okay, I will then direct that a pre-sentence investigation be conducted. How about 1 o'clock on August 1st? Let me double check. That may be a little too soon again for corrections. Let me count back again.
If we could get a different week than that, Your Honor. And I'd also be asking that it'll be available by Zoom so that at least one victim can participate by Zoom.
How about 1 o'clock on August 22nd?
The state can make that work.
That would be fine.
1 o'clock, August 22nd. I will then direct that this companion civil case 20 CB 254 be brought in on that date and time. Anything else to address today?
I'd ask that bond be revoked.
I will direct the bond be revoked. Anything else?
No, Your Honor.
No.
Okay. Thank you, everyone. We will recess.